All rise. The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for two cases. The case of Second Injury Fund versus Strabel is hereby submitted without oral argument. We are now ready for oral argument in the case of Feller versus State. Mr. Mears?
May it please the court. I'm glad to be able to come over here with today's weather in November rather than in January or February. That I'm here to present what Justice Judge Blaine described on the Court of Appeals as a difficult case. That Judge Schubert at the district court level also said it was a difficult determination. I think, however, and I appreciate further review being granted, that if you apply the balancing and the appropriate factors from the Fortune and Betcher cases, the court will conclude that this is not that difficult a case. There are...
Factual question, if you could help direct me. I bet you know the answer. Is there anything in the record regarding whether or not Feller's parental rights have been terminated?
I think that Judge Blaine said that there was nothing in the record to show that.
Question, I want to jump right into it if you don't mind. I don't know if it's been called a clerical error or what, but there, you got to admit there was a procedural approach that the prosecutor took, whether it was intentional or not, that definitely had a nasty outcome for your client by not amending the trial information to a lower offense and instead filing a new one. It kind of got it between a rock and a hard place, and then he ends up doing lifetime registry instead of 10, right? But correct me if I'm wrong. Did he waive that argument? Did he ever complain about it?
Well, he found out that it was lifetime. He had originally been told it was 10 years by the Department of Public Safety, that determination is in the record. They subsequently, when he was, prior to him being released, recognized that there was this fairly obscure provision in the registry statute that said that if you actually pled to two different case numbers, it was lifetime, and that he received that determination, I think, about when he was being released from prison in 2014 or 15. He did not seek any judicial remedy for that. That, quite frankly, and I've studied remedies for a long time, it's not entirely clear what the remedy would be, and certainly it's not clear what the remedy would be sort of 5 years later. It's possible that you could have done a post-conviction that I don't think it's probably an illegal sentence. It's probably a breach of the plea agreement. But in answer to your question, he didn't complain at the time.
Okay, he didn't, so maybe he's got a problem with that aspect. But should we consider it a relevant factor?
Absolutely. That is that. And one of the cases that the Court of Appeals decided against me was a case for a fellow by the name of Evans out of Scott County, and that Evans lost his district court case and then lost on appeal, with the district judge at least saying that since that was just a 10-year registration for Mr. Evans, wasn't that big a deal to keep him on the registry for another couple of years. That I think it's relevant. I mean, I think the procedural context is relevant because for several reasons. One, that the crimes themselves were non-aggravated offenses, meaning the crimes were ones that if you have, the difference between an aggravated offense and a non-aggravated offense is whether if it's the first one, is it 10 years or lifetime? And the legislature provided that the D felony lascivious acts was in fact a 10-year registration requirement. That Because of this, what I think of as a breach of the plea agreement, Mr. Feller has to register for life, and I think you can, when you think about balancing factors, that a decision that Feller has to register, and not only he has to register, but for life, that's an appropriate consideration. The same way in Evans, it was an appropriate consideration to think that in the balance, another couple of years isn't going to matter. I might add as well that Larvik was also a 10-year case, so that in the context of losing a modification case, you do in fact know that you're going to get out, you're going to get off soon.
Counsel, so are you asserting that there were some improper factors considered, or is it just the balancing that we're looking at here?
Judge Schubert didn't mention the procedural problem at all. Judge Bain,
Is your appeal based on concern about consideration of improper factors, or is it just the balancing part?
that it's consideration of improper factors or failure to consider proper factors, and then also that there is a lack of substantial evidence to support the factors that were considered.
When you talked about the judge's personal observations, I think I considered this to be like your fourth issue on the blue brief. Are you likening the judge's observations, such as demeanor and avoidance by affidavit instead of testifying, are you considering those to be non-validated assessments?
And that
An improper,
Blaine also said that those certainly were not, the courtroom considerations were not a substantial basis for thinking that he didn't have the appropriate level of remorse. That, I mean, that first of all, you don't, I mean, I think there was a recognition that the lack of eye contact with the judge was probably based on embarrassment. That, I mean, he was in the courtroom and his victim had testified, and this was presumably the only contact he had had with his actual victim.
You know, what you read about, if he was sitting there smirking and smiling, that would be something you would hold against him. But it does seem that just avoiding eye contact, that could just be a sense of shame. Is, you know, the opposite of a lack of remorse, really. Yeah.
Judge Blaine did in fact say that this wasn't a consideration with regard to the lack of remorse. That I also, however,
proper factors that you think the district court considered?
we do have to talk about the letters, because the letters in fact were an important part, or if not the major reason for the decision at the district court level. And that what, first of all, it appears, at least for years, these letters had been received and not opened and paid note, just stacked up someplace. But more importantly, it is undisputed, and we put the notes from the PO into the record, that this communication started with permission. That is, it was permission from both the PO and also the girl's mother. Whether consideration of the letters is an improper factor or is consideration of a factor that lacks substantial evidence to support it, 6 of one, half a dozen of the other. What's clear is that those letters are not evidence of a higher risk of reoffending. And there certainly is no substantial reason for purposes of public safety, which are the factors in.
District court seemed to find JB's testimony credible in that she reads those letters to sort of be setting up the same kind of, I don't know if grooming is the right word for it, but the same sort of plan or process that he did with JB. What are we supposed to make of that, particularly since the district court made a credibility call on that piece?
Difficult thing, because on the surface, grooming is being pleasant with your potential victim in order to get into the good graces of the victim. The two primary distinctions between grooming and what this evidence showed is that the victim of the crime was living in the same household with Feller during these 5-6 years or whatever it was. And secondly, the pushing was about having sex. And that here, Feller is simply, he never has any contact other than these letters and cards.
Somewhere. I mean, doesn't that give the older girl her argument a little bit more weight? You can't start right off with saying, let's have sex. No predator does that. It's going to start off with just plain, hey, how you doing? So isn't it important that the older girl said, that's the kind of stuff that happened to me? That's how it started.
He acknowledged, you never want to cross-examine a victim. And I did ask her 1 or 2 questions at the time. And the question was, wasn't the pushing, however, about sex? And she acknowledged it was.
To the sex point, but even leading up to it, she's saying, didn't she testify that this pushing, well, why not? Why don't you want, that's how it starts, and she's trying to prevent her little sister from even going down that path that ends up to actually being sex?
Been sent to the moon for all, anyone cared, because she hadn't opened them for years and didn't plan to open them, right?
Originally opened them and apparently responded a couple of times when they first had been because I think one of the notes from the PO that was introduced in the generic notes was that the mother was asking whether the girl could write back in sending some kind of a card. That there is no substantial evidence that the fact of these letters being sent and not opened that is a public safety risk.
Opening or not opening the letters, why is that material to the risk he poses?
Because it shows that the girl, particularly with a strong mother there, can make a decision on her own with regard to whether.
I do want to have sex with you, and when I'm off the registry, I'm going to come after you. And she didn't open them. Are you saying those are immaterial?
Well, if there had been anything like that, I assume they would have brought it into court.
I understand that, but I mean, what does her opening the letters have to do with the threat assessment that he poses to her?
When you offend against one daughter and have the second daughter, there is always the fear that the second daughter might have this happen too. What's the evidence, though, that little marginal fear is going to matter or is going to amount to substantial evidence of a substantial public safety concern?
First thing is just a minor little fear that he might perp on a younger sister?
Sorry?
Minor fear that he might perp on a younger sister?
That I suspect it is always a real fear, but that it's not.
Pretty grounded in prior cases and.
I think that is a example of a non-validated concern for risk, and that there simply isn't You know, one difference between Larvik and Feller is that Larvik had a mother who clearly had not protected the daughter. Absolutely, the mother in the Feller situation protected the daughter and wasn't going to allow anything.
Larvik's not a good comparison case. The facts are so different. That mom was not a cheerleader for that child. I agree. But I want to get back to the sisters thing. Are you arguing that if there's two families with two girls like these and one dad has never been accused, charged, or convicted of a sexual offense against a child compared to your client, are you saying that the younger sisters, in each case, neither one has a higher risk than the other of being sexually abused by that guy? Your argument was that I understand they might have a fear, but isn't that a genuine, real concern?
But is it a fear that amounts to a substantial enough fear to justify lifetime on the registry? That I submit that, you know, if you ask a mother, you know, are you worried about this happening again? The mother is undoubtedly going to say yes, and is going to be concerned about him doing it with other people, other families, and so forth. But that there's no validated reason for a low-risk sex offender it doesn't satisfy the Fortune criteria. My time is up.
Back, though.
May it please the court, counsel. I'd like to talk today, address a few of the questions maybe that were already asked to Mr. Mears, specifically Justice McDonald, addressing the question of, is it relevant whether JB opened the letters or not? And no, for the district court to look here at exercising its discretion, that whether she opened them or not, or this kind of, I guess, a subjective standard of whether is the victim concerned, or kind of some of these other subjective
That's not the test, is whether the victim's concerned. The test is, does he pose a threat to public safety? Because he's done his time. I mean, he committed a very serious crime. He's done his time. He's been punished. Punishment is over. It's now a regulatory issue of does he pose a concern to public safety? Because the registry poses substantial restrictions on the individual's freedom. And we do that only when there are valid regulatory reasons. Isn't that right?
Correct, yes. This court has said, I think, you know, specifically, you have to view these through the lens of public safety and not through the lens of punishment. And so I think it's clear here that that's what the district court and then the Court of Appeals was doing. And I think the important language from the Court of Appeals opinion, when it's talking about these letters, it says, you know, generally, if you look at these on their face, they're well wishes, they're kind of innocuous, but
Interrupt you because I think that is, I'm following you on that. But the Larvik versus State case, I do agree with opposing counsel that doesn't seem to be an appropriate case because the mother had rekindled a relationship. But I'll tell you what, I ain't terribly impressed with the mother of this case either. She's the one that gave permission. It seems really weird and incongruent to say, I'm so concerned. Sure, go ahead, write letters. And then later on, not only that, but the parole officer. So then I'm concerned. I'll ask you the same question. Were his rights terminated? Do you know?
the record, no.
There's no record that it was. Okay. Haven't you completely placed this guy in a catch-22? I'm looking at 600A, sub 83B2 in particular, abandonment. If your guy, or if his guy doesn't maintain regular contact, that's an automatic ground for TPR, and it's a darn good one. That's abandonment. You don't have anything to do. Okay. So if he does that with permission from parole officer and victim's mom, then he's in trouble for trying to reach out. Haven't we put him in a catch-22?
No, Your Honor, and I think for this specific reason that the argument about the mother in Larvik or distinguishing the mother from this really shouldn't be a distinction because that's what the district court's trying to do through the lens of public safety. Not looking at is the mother in each individual case, somebody that can protect this person. That in and of itself assumes there's something to protect her from. By arguing that Larvig is distinguishable because the mother in this case, as the appellant argues, is much more attuned to, safety issues, that also, that's the argument of, somebody that burglarizes homes that, well, this person locks their front door and this person doesn't, so that's the distinction. The intent of, the danger itself is, I think, what the district court had to look to here, regardless of, is the mother protective enough? And I think that's what the registry is based for, is for the individual. That is what I think the appellant argues about the Larvig decision. I think that is correct, the Court of Appeals decision in Larvig, that an individual is a member of the public and they are protected under the statute. And that is in line with the statute. The statute for registry doesn't say only people who offend against multiple people in the public must register. So, seemingly, as this court's seen, there's lots of cases where people offend against, children, stepchildren. The registry doesn't require that, well, it's a register for life or even for 10 years, it has to be against multiple members of the public. The court has to look at, is there a substantial evidence of a public safety risk here? And I think the Court of Appeals really put it, context matters. The letters in and of, if you take each little thing and break it out, maybe that's not enough. But when you put it all together and the district court looking at it with the discretion that it's been given.
Revoke her permission?
There's nothing in the record that she ever revoked her permission.
Along for how many years these letters went on, and then when it's time for him to say, I would like some reprieve from this, then all of a sudden she says, no, those letters were a reason you should stay on the registry. Isn't that inconsistent?
The mother's testimony below is that, and I think along with JB's, is that the letter started for about a 10-year period, 2012 to 2022. And again, I think the notes that are in an email from the probation officer show, I think 2015 is when the first note starts, but the letters actually start back in 2012 when I think he's incarcerated, and shows there might have been some communication between the daughter and him at that point.
Did any of them include something that a mother should have turned into law enforcement as a threat or a fear?
As a threat or a fear, I don't think there's anything in there that would be considered a threat or a fear.
Need to let them be?
Perhaps. Again, it's unclear in the record what exactly her reasoning was. She did say that she had put some restrictions on the permission, which is she wanted it just to be to, for JB, or JF, just for her well-being and not anything further. And so I think the district court and what JB testified to really is that it's the push, it's the theme that he used throughout the letters, that it became more about him than about his daughter. It was more about, what haven't you done for me? I haven't heard from you.
If we took the letters out of the mix, is there substantial evidence to support the district court ruling keeping him on the registry?
The letters are out of the mix, and I think the testimony by JB would be out, and so no, I don't think on the record there would be enough for a substantial finding. The basis for the courts, the main basis was this substantial evidence of, I think, the volume of the letters, the persistence and theme that's within the certain letters that were testified to by JB, and really JB's testimony. I think the language from Fortune that this court used was that it may be possible to identify increased risk based upon what appears to be repeated patterns of behavior, and that what might be ordinarily innocent behavior that might look more suspicious in light of the facts of the underlying crime. And that also the threat to public safety must be tied to the individual applicant and the record established in each case. So here you have this individual applicant, and you have his former victim saying, and again, I think this directly speaks to Fortune and what the district court looked at, which is on its face, are these, are letters from the father to a daughter an issue? And as the Court of Appeals said, but you have to look at this in context. The troubling language that begins to kind of reemerge as a pattern based on volume and context.
I agree, the letters are pushy and they're sort of self-absorbed rather than focusing on her. And that may just be the way his personality is. But here's the way I look at it. I agree. Public safety can't, it's not just the threat to the general public, although we're concerned about that. But as far as the threat to the general public, he's been out for 10 years. He's lived a clean life. He hasn't gotten in trouble. He hasn't done, there's really nothing out there, as you say. The only threat that the state's relying on here is this threat to this daughter. And here the evidence is she was 15 at the time of the hearing. She hadn't been reading the letters for years. And the mother she felt that she could protect her daughter. And the letters, while maybe pushy, were not improper in the sense that they talked about anything inappropriate. It seems pretty thin to, again, impose these very substantial restrictions on somebody's freedom. Help me.
Again, as well, to go back to what the Chief Justice said, it has to start somewhere. So again, I think looking at the letters from the district court's perspective and in these type of cases, we're in that second prong of really the test. We have that first step, that is, to get here, you have to be classified low risk by DOC. So any of these cases are necessarily probably going to be on, closer calls, because anything so, overt would probably not qualify you as low risk. And so that's why the district court, and we give the district court that discretion, to listen to witnesses, to look at demeanor, to assess credibility on these difficult questions, and what is there to keep somebody on the registry, and balancing that. And so here, I think the district court did that in tying the testimony with the letters and with the past patterns of behavior. That's enough to be substantial evidence to keep him on the registry for that protection of the public's reason.
Oh, go ahead. I can't recall, but under the statute, who has the burden of proof to be removed from the registry?
That it's not really discussed in Fortune or Betcher. Ordinarily in any case that there's a civil proceeding, that somebody that's asking for something as an applicant would generally have the burden to show. But the way that I think some of the language in Fortune and comes down, and then some of these court appeals cases kind of shifts that burden almost to the state, where the statute simply says the court may hold a hearing and that it may consider any evidence as relevant.
Be removed.
Right?
When could he petition again to be removed?
That says there's a time frame or in the related statute. So, based on the statutory language, whenever.
Would you agree with me that the quirky county attorney's choice, or assistant county attorney, to refile a new charge instead of amending down, would you agree with me that that is a relevant factor? Whether it was, 10 years versus lifetime is quite a gap.
Possibly if we had a record that was a clear record of it. I think the Court of Appeals footnotes that in footnote 5 of its opinion, saying,
Would that be a relevant factor?
assuming it's true, I don't think it would be a relevant factor for these type of proceedings, given that there are other vehicles and other remedies that somebody would have, whether it's through a 17A challenge that, I think the record here is that in 2016, Mr. Feller received a decision from DPS saying he's a lifetime registrant now. And it appears he disagreed with that based on his understanding of where he was at. So at that time, he had remedies under 17A to challenge that through those proceedings, or again, whether there'd be a PCR to challenge whether a plea agreement was breached, or I think, is it an illegal sentence issue? Again, I think the Court of Appeals addresses, on the absence of the record, it's hard to say.
A relevant factor. If the district court did not consider that as a relevant factor, what do we do? Doesn't Fortune say failure to consider a relevant factor is an abuse of discretion?
It says that, yes, if there's a relevant factor, and again, I think it's somewhat difficult to say exactly how to apply that analysis, because the court looks at the standard of review as an abuse of discretion and says this is different than sentencing, but then cites to, I think, Roby twice, a juvenile sentencing case. And then in Betcher, I think more so stands to the standard of review that cites to multiple cases of, the court using its discretion on attorney fees issues. So
You mentioned that because there's another issue and your time is almost up. I want to ask another question. When the district court talked about lack of remorse and all that jazz, that sure sounds like sentencing to me. Does it to you?
Does the district court's discussion sound like sentencing?
About a judge making a comment, I see no remorse. I see a lack of remorse. Isn't that a typical conversation that a court might have in the courtroom or in his or her order at sentencing? Sounds like punishment to me.
It could be. I think in this, you have the one sentence or two sentences that the district court uses here to say the remorse was tied to the, I think, observations that the court had of the appellant to the testimony of the victim. And so whether that is improper, again, the judge is given discretion in these to look at what it finds relevant. And I guess to the extent that he's looking at how somebody that might have the burden to show, why should we let you off the registry?
Is it an abuse of discretion failing to consider relevant? It's also abuse to consider an irrelevant or improper factor. And I'm just wondering if, and even the fact that he used an affidavit instead of testifying, am I correct that he could have been crossed? He was sitting there, right? So what? If he just wants to put his direct on in the form of an affidavit, what's the complaint? Why couldn't the state have called him and said, get up there, I want to cross you?
They didn't, but I think that's reasonable. And again, in the civil case, it does go back to, I think this open-ended question of, as Justice McDonald said, who has the burden? And then as the statute says, it doesn't say that the state must prove something. It simply says the court can consider. So can
The fact that he put on an affidavit but didn't testify, yet the state could have called him if they wanted to, does that indicate that the court was considering an improper factor?
No, I don't. I mean, I think the fact that he considered that he put in an affidavit instead of testifying is a relevant factor that the court should be able to consider. Depending on, again, for the court's purposes, what he hears in an affidavit is limited to what is in the affidavit and not what somebody is testifying to. In one sense, it could be under, kind of taking that to its conclusion. In these cases, it would almost be better for an applicant to do really nothing and say nothing other than just apply, and then the court is left with, well, what record do I have? And again, I think the statute's unclear. Does that then shift to the state to say, you must prove, that this person meets these factors or doesn't meet these factors? I think Fortune and the statute don't directly state that. But again, I think for this case, the untenable, unreasonable ruling by the district court under the standard of abuse of discretion should be applied. And I think here there is reasonable efforts by the court. I see my time is up, Your Honor, so may I finish 1 second? So I think we would ask that, based on this record, that the Court of Appeals and the district court opinion be affirmed. Thank you.
I only have about 14 things that I want to say. I probably won't be able to say that. One of the things that was kind of interesting was that in the Larvik District Court case, that the district judge, and I think this was in the transcript, explored the possibility of imposing a no-contact order in the modification case. He eventually concluded that he couldn't do that. But that illustrated the fact that there was, to the extent that there was an argument that there was a risk to the one person, that person already knew completely about the crime and the fact he was on the registry, and that the judge in Larvik thought that if you could just impose a no-contact order, that would essentially take care of it. He didn't do that, and Larvik eventually lost. But the point is that there is no, to the extent that there is a risk, it is a apparent risk to this one child. A child, I might add, who is now 15 or 16, probably closer to 17 at this point.
Provide additional information to that child that wouldn't be available under a no-contact order?
That the registry would provide where the person lived.
Would be a relevant consideration, wouldn't it? If she were to find out that he lived a block from her?
Relatively small town, and Dubuque is a relatively small town. I don't think it matters. I mean, that the the girl, I mean, that family knows where he lives, knows where he works.
Well, are you saying that if the district court has considered the evidence and made a determination, your client is a threat to perpetrate on a minor, a specific minor, that's not enough, that they need to make an additional inference that not only is he a threat towards this one minor, but that he would also go on to other minors as well. Is that what you're saying?
Saying that this fortune criteria says that there has to be a reason for the public safety concern is tied to the registration requirement. And the question is, does the registration requirement make this girl any safer than she would be without it? A couple of other things I really want to say, though, that family offenders, in fact, actuarially are the lowest recidivism rate of all sex offenders. There's some kind of...
To hit again on another family member or general public? What is the recidivism towards? To offend at all?
that there is something called desistance that I mentioned in there. And the desistance is equated with risk level 1, which is the static term for the lowest risk. But desistance, there is a risk if you took statistically all the people who were coming out of prison or being placed on probation for non-sex offenses and asked what is their risk for committing a sex offense, it would be about 2%.
Is that in the record? Okay. Question, who has the burden of proof?
It is clear under Fortune that there is a balance. The Fortune says that if the person satisfies, or I guess it's Betcher says, if the person satisfies the criteria, that's weighty evidence in support of modification. I submit that if you have a low-risk person, particularly risk 1, that creates essentially a presumption that can only be overcome if the state can come in and show some kind of remarkable evidence that outweighs that. So in answer to your question, probably the applicant bears the initial burden, but if the person starts out with satisfying the criteria, particularly being the lowest risk, that essentially would, as a practical matter, shift it.
How many years were letters written?
I think the first one is got a postmark on it, which is, I think, 2012, and that the test...
Ish. Okay. And then if he, there's something, I agree that the mom gave permission and the parole officer gave permission, but then it does kind of make me wonder about your guys' motive. I mean, he knows for a fact that he was convicted for sexually abusing this girl's older sister. And to write someone, a young girl, even though it's his daughter, I don't care, for 10 years and never get a response, and to do it every single month, that's kind of creepy.
Get responses, some responses for a while.
For 8 years, none. Isn't that kind of creepy?
You know, there were times when we were somewhat estranged from one of our daughters, but that we continued to show up and we continued to communicate and so forth.
And sexually abused one of them.
Excuse me.
Case.
But again, the younger daughter was like 4 when he went away to prison. And she was a bio daughter, which, you know, that in the world of things, it's still a daughter is a daughter, but that
A pedophile. You don't have to be related.
that pedophiles can have the risk of reoffending be so low that they don't need to be on the sex offender registry for life. Thank you for your time. It's a difficult case. I'm not sure I convinced you it was not a difficult case, but I hope that you will decide that in fact, John Feller does not need to be on the registry any longer. Thank you.
Mr. Kenworthy, the case of Feller versus State is hereby submitted, and court is adjourned for the afternoon.